Swayam Prabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law. The second class will talk about basic concepts of law of the sea, which will be part 1 as far as law of the sea is concerned. In the last class, when we were discussing about historical developments of maritime law, I had identified 3 players or 3 subject concerns as far as maritime law is concerned, and that would be ship, state and sea. It is pertinent to know about the rules and regulations of the sea area. Without knowing the rules and regulations pertaining to sea area, it will be difficult for us to understand the relationship between ship and sea. At the end, both of them connected to state, the ship as well as the state, the sea. And how sea gets regulated, in what manner it gets regulated, all of which will be discussed under 3 parts or 3 parts that we will take into account in today's lecture, in the upcoming 2 lectures as well. So, the learning objectives for today's class would be to understand the different maritime zones. So, as I said that sea has been divided into different maritime zones, and these different maritime zones endorse different rights and obligations upon the state, at the same time rights and obligations upon the ships. And when these rights and obligations come together in a corollary manner as against the state as well as against the ship, we see that a concrete rule and regulation has been identified in modern times. History has been telling us, for which you can refer the last lecture, that there had been conflict between the 2 different ideas, that is freedom of navigation and the restriction over the navigation. The 2 different ideas propose or give preference to 2 different aspects. Where we talk about mare liberum, it gives preference to navigation. Where we talk about preference given to state, it talks about mare clausum, that ships should be restricted as far as coastal waters are concerned especially. So, in given this scenario, it was pertinent and it was necessary that you have significant rules and regulations, especially codified ones, that can make uniform the passage of ships, the existence of sovereign rights, territorial aspects, etc., as far as coastal states are concerned. So, we will today understand the different maritime zones, and these different maritime zones are the zones attached to the coastal state. So, if there is a coastal state, the water attached to that coastal state will be divided into different maritime zones. Then to understand the measurement of maritime zones, once you have maritime zones, what is the measurement? How do you measure, from which point do you measure, up to what point do you measure? In the last class, I have given you a brief peripheral overview as to what is the measurement, but how it is done will be understood in today's class. Then to learn legal regime of baselines. Friends, what are baselines? Baselines are the lines from where or from which or from the point from where the breadth of the different maritime zones are measured. Let us assume that you are standing on a coastline. Let us say you are standing on Indian coastline in, let us say, Kanyakumari, or standing in Chennai. You have a sea water in front of you. It is what point from where you start the measurement. Whether you start the measurement from the area where where the water is coming and going, whether you start measuring from the point where there is movement of tides, or what is the exact point from which measurement should start, and what is the rationale behind identification of such point. Whether any other method or problem comes into being, If there is any other method or problem that comes into being, then what is the solution, what is the other method, all of which will also be answered in today's class. To learn different legal regimes of baseline and to learn different rights and duties of coastal and flag state. As I have already told you, coastal states have its own concern as well as navigating ship has its own concern, and this navigating ship's concern is identified under the heading flag state. We also have flag state jurisdiction for that matter. Let us say if a ship is passing through either territorial water or any coastal water, whenever a ship is navigating, as far as jurisdiction with respect to that particular ship is concerned, primarily it will always be with the state whose flag it has put upon the mast of the ship. So, whosoever's flag it is flying over the ship, that particular state will have the jurisdiction. In modern times, we say wherever the ship is registered, the ship will carry the flag of that particular state, and that particular state will have the jurisdiction over any subject matter, over any dispute, over any problem that comes into being as far as that particular ship is concerned. Friends, problem do come into picture when there is interaction of one ship with another ship belonging to two different flags. In such a situation, how do you identify the jurisdiction? We will discuss that in the upcoming classes as well. To enable the learners to identify the application of jurisdiction in different maritime zone. So, once we say that there are different maritime zones, let us say in the last lecture as I told you that there is territorial water, then you have contiguous zone and exclusive economic zone or continental shelf. What is the difference of jurisdiction? What is the level of sovereignty that can be laid down? What is the intensity of right or rights as far as coastal states are concerned in territorial water or in contiguous zone or in other zones? At the same time, what is the intention of right in what is the intensity of right and duty of a flag state when it travels or navigates near to the coastal state or from any of these zones? We will discuss that as well. To learn and understand the doctrine of hot pursuit. Friend, hot pursuit here signifies chasing down a particular ship. Why do you chase down a particular ship? The object behind chasing down or chasing a particular ship may be that a ship has committed a wrongful act. In order to arrest that ship, in order to investigate that ship, in order to take any action against that particular ship that has done a wrongful act within your territorial boundaries, hot pursuit is carried out. Hot pursuit here signifies pursuing a particular ship that has committed the wrongful act. What is the law pertaining to hot pursuit will also be discussed in detail as far as today's class is concerned. So, let us begin with the general idea and identification of different maritime zones. As you can see friends here that you have a territorial sea which extends to 12 nautical mile, as you can identify has been written here in the pictorial representation. Let us understand that from a particular point near to the coastal state or coastline, this measurement starts, and this point is, or you can say one point connected to other point and creating a straight line. Once these points are identified at a particular coastal area. So, let us say this is India's southern territory, and if this is the land portion, a certain particular point will be identified. A certain particular point will be identified which will be joined together, and from these points the measurement will start. So, a line is created by joining these points. So, once a point is identified and a line is stretched around the coastline, 12 nautical mile from that particular point would be territorial sea, as you can see here. From this point up to 24 nautical mile, you have contiguous zone. And from this point, that is where the territorial sea ends, and up to your next 12 nautical miles, you will have contiguous zone only. But here you are having both in this particular region, you can see both contiguous zone as well as territorial sea, but here only contiguous zone. At the same time, we can see that we have the measurement of exclusive economic zone, which can be considered to be a third zone, which starts from the point where the territorial sea ends and goes up to 188 nautical miles. If you measure it from the point from where territorial sea begins, or from the point where territorial sea is measured, that is from the baseline, it goes up to 200 nautical miles. So, the measurement starts from the baseline only, be it territorial sea or contiguous zone or exclusive economic zone. For all calculations, this would be the point of beginning, and it can go up to 12 nautical mile, or it can go up to 24 nautical mile, or it may go up to 200 nautical mile. The region beyond territorial sea is up to next 12 nautical mile would be an overlapping of EEZ, that is exclusive economic zone, and contiguous zone. From the point where contiguous zone ends, that is post 24 nautical miles measured from baseline, you have only EEZ. So, in totality, the measurement should start from baseline. There will be overlapping in the first 12 nautical mile and as well as in the next 24 nautical mile, but post 24 nautical mile, that is here 166 nautical mile would be only 176 nautical miles would be only exclusive economic zone. What is the purpose of EEZ, contiguous zone and territorial sea will be discussed in detail in the upcoming slides. But here we need to understand the measurement, that what is the measurement of these different maritime zones. Friends, if you look at the history, there was quite a concern and quite a discussion then went ahead as far as identification of 12 nautical mile, 24 nautical miles and EEZ. Why 12 nautical mile? Why 200 nautical mile? As far as territorial sea is concerned, if we look at the history of the finalization of United Nations Convention Law of the Sea, we can easily identify and we can easily see that number of states had different concerns as to the breadth of the territorial sea. The advanced states largely wanted to have more and more control over the sea. They wanted to lay down intense, grave and quantified in a larger manner more territorial waters. That is, they wanted more rights over the territorial waters, over a larger share of water as much as they can get. So, different proposals were made while UNCLOS or conference for UNCLOS was going on, and under these different proposals, some states had proposed 6 nautical mile to be territorial water, some proposed to be 10 nautical mile, some proposed to be 3 nautical mile. So, there was different approaches that were placed or different breadth that were proposed. The maximum approach was that of 12 nautical mile, and which was uniformly accepted by all the states, that is 12 nautical mile. Now, what is the calculation of 12 nautical mile just in a general manner if we want to understand? Approx 1.86 kilometer would be equal to 1 nautical mile. So, approximately 22 kilometers of water that is attached to a coastal state, sea water attached to a coastal state would be categorized as territorial water. And then the next post 22 kilometers you have another approximately 22 kilometers in totality. From baseline it would be 44 kilometers would be that of contiguous zone, and then EEZ. So, taking maximum range or breadth of territorial breadth of the water as in out of all the proposals made was the rationale behind providing territorial sea of 12 nautical mile. As far as our exclusive economic zone is concerned, it is not an idea or it is not a zone that was in existence traditionally. The traditional idea has been continental shelf. However, there were problems pertaining to the breadth of continental shelf, since the advanced states such as USA, UK and other states, Russia for that matter, USSR at that point of time, wanted to have maximum share, unrestricted share of water. They wanted their continental shelf to extend up to as much possible limit as possible. So, this was not accepted by especially the developing and least developed countries, especially the countries that got decolonized in the 60s, 1960s, 1950s and after that, because they were still struggling to maintain internal peace and security of their land territory. Forget about extracting resources from continental shelf regions. So, they wanted certain limit to come into being, so that the advanced or technologically developed states do not interfere into the region, into the area which is exclusively provided to those developing and least developed countries. So, there must be uniformity as far as rights over exclusive economic zone is concerned. So, there was lack of any such idea which is now known as exclusive economic zone. No exclusive rights were provided to the states. If the states have certain continental shelf attached to their coastline, then they can utilize that particular continental shelf for economic beneficial purposes. At the same time, the developing or least developed states also wanted to have their own continental shelf. At the same time, they also wanted to have a uniform mechanism that if economic rights are provided, it must be equal for all the states. It must not be divergent for different states. It must not be based on might and power that states are possessing. So, where there is inequality with respect to state power, the lesser advanced states with respect to science and technology wanted to have exclusive rights over economic importance or economic rights over the sea, and therefore, exclusive economic zone comes into being, which was fixed as far as exclusive economic rights were concerned, and this fixation was made up to 200 nautical miles. Now, exclusive economic zone, whosoever has signed the United Nations Convention on Law of the Sea is bound by the exclusive economic zone, with a small exception of extending beyond 200 nautical mile, and that extension can then be termed as continental shelf. So, if you talk about exclusive economic zone, it is restricted up to 200 nautical mile, but if a state wants to extend or go beyond 200 nautical mile, it will have to establish certain considerations which are provided in United Nations Convention on Law of the Sea, and based on those established considerations only it can go beyond 200 nautical mile. What are those considerations? We will be discussing that as well. So, therefore, largely for states exercise of rights, you have or we have territorial zone, contiguous zone and then exclusive economic zone. Apart from these three zones, another traditional right which begins from the point where territorial sea ends and can go up to maximum 350 nautical miles. So, if a state is having continental shelf, it should not be more than 350 nautical mile. The seabed area, friends, upon which the water column resides goes deeper and deeper and deeper. So, as we see going it deep, the continental shelf comes into being. most of the resources, friends, are found in this deep sea bed, which is either covered by the continental shelf or may be covered by high sea region. So, from the point at the point where your exclusive economic zone ends, high sea can begin, or if the point is extended up to 350 nautical mile, then from this point where 350 nautical mile ends, high sea can begin, and there are no sovereign rights, economic or of whatever nature, that will come into being as far as high sea is concerned. High sea is considered to be common heritage of mankind, and if high sea is considered to be a common heritage of mankind, friends, then it has to be preserved, it has to be protected. If any resource is found, then what are the rules and regulations with respect to resources found in high sea are concerned? Well, friends, there is a separate body that has International Seabed Authority has been made, which takes care of the resources found in the high seas. At the same time, the resources found in the common heritage of mankind belongs to all the states, it will not belong to one single state. So, what is the method of distribution, what is the what are the regulations that take care of distribution of resources or the payments that are to be made, all of which has to be taken care by part 11, that is International Seabed Authority, its functions, etc., rules and regulations have been mentioned under part 11 of United Nations Convention on Law of the Sea. So, taking this into account, let us understand the concept of baseline, because it becomes very important and pertinent, since it is this point from where the calculation of breadth of the different maritime zone has to be made. So, let us see, friends, here, let us consider that this is the land area and this is your coastline. Now, how do you start measuring baseline? Well, friends, baseline is to be measured from the low water mark point. What is a low water mark point? It is the point where low tidal elevation, low tidal point comes into being. What is a low tidal elevation? Just if you imagine and assume that there are, if you are standing at the shore, if you are standing at a coastal area, coastal region, let us say Chennai or let us say Kanyakumari or Goa or Kerala, you will see, or Gujarat for that matter, you will see that there are tides coming and going. If you are standing at the beach of Puri, you will see tides coming into being, coming towards you and then going back. There is continuous movement of water as far as the shore is concerned. So, from which point do you start measuring? So, it is the point where the water can be considered to be fixed and it can be deemed that it will not move. There, it is the point where it will be deemed that water will always be there and it will not empty the area and it will not bring up the land surface above it. So, it is the point where the tidal point or where the tides are coming to an end, or you can say are the lowest as compared to the front area. Front area means the tides which is attached to, or tidal area which is attached to the land surface. So, low tidal point is the point from which or from where you start measuring your territorial water, contiguous zone, or for that matter exclusive economic zone or any other zone. So, let us say this is the land area, the low tidal points are earmarked. So, if you can see the picture, marking low water points, which might be little different. Let us say you have a rocky structure here. So, your low water mark will not be equivalent to this point or this point. Your low water mark point might come here, and then for this particular area it will be here, it will be here. So, different low water mark points can come into it. Let us say you have an island situated here, which is very, and you have a high tidal area in this particular region. So, in that scenario, the low water mark will follow this particular island and then go back to the main, towards the mainland. So, all these dots then are joined. Once you join these dots, for here if you have a rocky structure you will join here, then it will come again near to the mainland. Then when you join all these points, a baseline is then formed. If you look at the outer line, your outer line will be known as baseline, and from this point then you start measuring, which will be 12 nautical mile or your 24 nautical mile territorial sea or contiguous zone, or for that matter your EEZ. So, accordingly from these points you get to start measuring. This is a simple method which has been followed for many years and even today as far as measurement of baseline is concerned. Now, friends, it is not simple as we have discussed just now. We have taken a very simple example where there is only one rocky structure, perhaps one island, and sometimes not even a rocky structure or an island. Sometimes the coastline is so complex that it becomes difficult for stretching a particular baseline or marking a particular baseline. If you look at, for example, the coastline of let us say Norway, or for that matter Netherlands. If you look at the coastline of Netherlands, it has so many jiggars that it is having this kind of zigzag structure. Can you draw a baseline into going into this particular, can you create a low tidal point into this particular zigzag structure? They are so narrow and minor as far as their geographical structure is concerned, that it becomes very difficult to draw a baseline in a normal scenario. So, you require a certain special or a specific method through which baseline can be drew. Also, it is pertinent to note that when states have such zigzag structure, they have jiggars, or if they have rocky structures, a long streak of rocky structure is present near to their coastline, and the tides are very heavy between the coastline as well as these rocky structures. It gives you a disadvantageous position, or it places you at a disadvantageous position as far as drawing of baseline is concerned. A simple normal baseline cannot be drawn. So, therefore, we can adopt another method which is provided not only in United Nations Convention on Law of the Sea, but can be traced through a certain historical practices as well. This historical practice was concretized and recognized in Anglo-Norwegian fisheries case, and this practice is known as drawing of straight baselines. So, let us first understand what and how straight baseline is and is drawn respectively, and then we will look at the case as well, and we will also look at the rules pertaining to drawing of straight baselines mentioned under United Nations Convention on Law of the Sea. So, let us say friends that such is the baseline, this is one of the baseline, or let us say this is a simple baseline, but you have rocky structures here. Now, if such is the baseline, then as I said, it is difficult to go inside and draw a baseline like this. But if you draw a dot here and you draw a dot here, you draw a dot here and connect the outer points, then it becomes comparatively easier to draw a baseline. It also gives you solution to the disadvantageous position that a state is having because of such a zigzag structure of the coastline. At the same time, if a state is having rocky structures in front of him, if in front of the coastline, then it becomes difficult for the state to have a baseline here and then extend beyond the rocky structure, which will again be disadvantageous for the concerned coastal state. So, therefore, in order to simplify this particular aspect, a baseline can be taken into account where there are rocky structures by drawing baselines from the point where there is a low tidal point attached to this rocky structures. So, low tidal point of not the coastline or coastal state will be taken directly, but low tidal point of the rocky structure will be taken into account. And once these low tidal points are identified, you create a single line. If you look at the normal baseline method, which would be, let us say, like this, and the baseline would be this. It is not straight, but if you compare it with the coastline, which has having a low tidal point because of the zigzag structure or because of the presence of rocky areas or rocky structures near to the coastline of the coastal state, then you can see we have a straight line coming into being or near to straight line coming into being as far as such peculiar scenarios are concerned. So, the present law as well as the practice has been to draw such straight lines where such peculiar coastal instances are present. So, in such exceptional scenarios, you can divert from the normal baseline method and follow straight baseline method. Now, you can do so based on law mentioned under United Nations Convention on Law of the Sea 1982, and at the same time court has recognized in Anglo-Norwegian fisheries case that if there is a long practice that has been followed by the state for a longer period of time, because of the rocky structure or because of the geographical or geomorphological conditions of a particular state, then you can diverge or divert from the normal baseline method and adopt a straight baseline method. If there was no objection that was raised by any other state because a state was following a straight baseline method, then because of non-objection it can be considered to be a customary practice by the state that was following a straight baseline method. So, taking all of that into account, let us now discuss what does the law say in today's time. So, as I said, baselines can be of two types, normal baseline and a straight baseline. Normal baseline I have already explained you, at the same time straight baseline I have already explained you low tidal point and how those dots of low tidal points are connected, and from those points only territorial waters, contiguous zone and other zones are getting measured. So, if you look at normal baseline, article 5 of United Nations Convention on Law of the Sea says the normal baseline for measuring the breadth of the territorial sea is the low water line along the coast as marked on large scale charts officially recognized by the coastal state. So, friends, I have already told you what is low water line, and from that point along the coast it gets marked. So, if that is, it is Indian boundary coastlines of southern states, then we can identify low water points, and these low water points once joined will be baseline, and from here your measurement will start accordingly. Similarly, straight baseline mentioned under unclause, but as far as its origin is concerned, it was first adjudicated and discussed in Anglo-Norwegian fisheries case between Britishers, English and the Norwegians. What are the facts of this particular case? Friends, in Anglo-Norwegian fisheries case, the state of Norway was having a particular practice, and that practice was with respect to drawing a straight baseline and then starting all the measurements from that straight baseline. It was the claim of English against Norway or Norwegians that since you draw a straight baseline, what happens is that the concerned coastal state gets an extra share of internal water. So, accordingly you will get an extra right over the sea water. So, this gives more water, more control over the water, or you can say quantitatively larger share of water comes within the sovereign rights of the coastal state as compared to other states. So, if all these states are following normal baseline, they will have lesser internal water. If other states are following a straight baseline method, the states that are following state baseline method will have a larger internal water share. So, since it is unequal approach, therefore, this particular case. So, in this case it was said that there are a number of ways that international law can be developed. The most obvious way is by nations making treaties and conventions. Another way is customary law. So, since in this case no treaty or convention was available when this case was referred to the Permanent Court of International Justice, we see that absence of any treaty and convention led to non-finalization of practice or non-finalization of the dispute as far as a state baseline or normal baseline method is concerned. Certainly friends, normal baseline has been considered to be the normal practice or generally accepted practice around the globe. But here Norway has followed a state baseline method and it has a reason to do so, and the reason is the structure of coastline that it is having, and due to that structure of coastline it has been following, which is zigzag in nature, as I said. Due to that structure, the state baseline method has been followed. It becomes almost impossible for the Norway to draw a normal baseline and then start measuring from that particular point of baseline, and therefore, whether the state baseline comes up as a practice which is accepted as universally accepted practice or generally accepted practice, whether it is customary in nature. If it is not customary in nature, then certainly it is not accepted, or it will not be accepted as law. We must also note in this fact that for hundreds of years, for more than 300 years, Norway has been in practice with respect to measurement of baseline, and it has adopted the practice of state baseline method, and English did not object it for a longer period of time. Rather, we have a practice of 200 years where English did not object, rather accepted this particular practice. Why do I say that they have accepted? Because they did not object to it. Since they did not object for a longer period of time, it can be deemed that they have accepted it. The rationale behind drawing a state baseline goes again to the fact that they have a very zigzag kind of coastline present as far as Norway's coastline is concerned. So, therefore, if you look at customary law, it reflects the ways that nations dealt with one another before we had a more formal system of international law. The court found that Norway had used the rocky outcrops as its baseline for centuries. Friends, as I have already explained you that once you have rocky structures, it becomes difficult for the coastal state to draw a baseline, since the presence of rocky structure makes it impossible, or you can say difficult, and therefore, low tidal point beyond rocky structure would act as a baseline, and that will be straight in its construction. Therefore, the court found that the Norway had used the rocky outcrops as its baseline for centuries, and that other nations including Great Britain had allowed them to do so. The court said historical data produced by the Norwegian government lend some weight to the idea of the survival of traditional rights over fishing grounds. Such rights, founded on the vital need of the population and attested by very ancient and peaceful usage, may legitimately be taken into account in drawing a line whichever appears to the court to have been kept within the bounds of what is moderate and reasonable. Norway was therefore allowed, in accordance with customary international law, to calculate its territorial waters from the edge of the rock outcrops. Court also considered the 300 years of practice of customary law. The United Kingdom never objected to it in 300 years. Therefore, we see with the advent of this case, we see, or with the decision of this particular case, we see that a state baseline method was also accepted as a customary rule of international law or customary law, provided the essential reasoning is available and which will arise from geographical considerations of particular coastal state. Article 7 of the United Nations Convention on Law of the Sea says, under clause 1, that if there is a fringe of islands along the coast in its immediate vicinity, the method of state baselines joining appropriate points may be employed in drawing the baseline from which the breadth of the territorial sea is measured. The drawing of state baselines must not depart to any appreciable extent from the general direction of the coast, and the sea areas lying within the lines must be sufficiently closely linked to the land domain to be subject to the regime of internal waters. So, when it says that it must not depart from to any appreciable extent, let us say that there is a coastline and there are rocky structures available here. So, it must be the nearest point. Once you draw your state baseline or employ a state baseline method, it must be the nearest point. It should not go too beyond, let us say it should not be here when you draw your state baseline. So, the appreciable extent is little bit subjective depending upon the concerned coastline, the structure of the coastline, the geographical structure of the coastal state will identify factually that whether it is going beyond appreciable extent or not going beyond appreciable extent. Clause 5, where the method of state baselines is applicable under paragraph 1, account may be taken in determining particular baselines of economic interest peculiar to the region concerned, the reality and the importance of which are clearly evidenced by long usage. So, therefore, since customary law requires practice, that is the conduct for a longer period of time as well as opinio juris, here for a state baseline practice becomes an essential aspect which must be undertaken or which have been undertaken for a longer period of time, an essential aspect to culminate itself into a customary law. Clause 6, the system of state baselines may not be applied by a state in such a manner as to cut off the territorial sea of another state from the high seas or an exclusive economic zone. So, states are exceptionally allowed to draw state baselines, however, they must take into account that they are not cutting into the territorial waters or exclusive economic zones of any other states which are either opposite or adjacent to the concerned state. Now, friends, let us now talk about the legal status of territorial waters. Since we have already identified now that what are the different methods of drawing baselines, once baseline is identified, you draw the territorial sea. We know the measurement or the breadth of the territorial sea, but what is the legal status of the territorial sea? The legal status of the bed, subsoil, suprajacent airspace of the territorial sea falls within the territorial waters, that is the seabed area over which the water column is residing, that is, let us say if this is the seabed area, then you have a water column above. So, the rights of the state is not only extending to water or upper part of it, but to the whole water, to the seabed and as well as the airspace above the water area. The breadth of the territorial sea, that is article 3 of the law of the sea convention. It says that every state has the right to establish the breadth of its territorial sea up to a limit not exceeding 12 nautical miles measured from baselines determined in accordance with this convention. We have already discussed that. The right of innocent passage, article 18 of the law of the sea convention says passage includes not only actual passage through territorial sea, but also includes stopping and anchoring insofar as this is incidental to the ordinary navigation or rendered necessary by force majeure or distress. So, friends, in the last lecture we have talked about freedom of navigation. Even when we started with this lecture also, we see that once there is territorial sea, the state can have right, but at the same time there is freedom of navigation which is available at all times to any navigating ship. So, it is one of the primary right of any ship that is navigating either through territorial water or through high seas or through continental shelf. And this innocent passage, so you are allowed to pass through territorial waters or any other area of the sea water attached to the coastal state, but then at the same time that passage through territorial sea must be innocent. That is, in general parlance we can understand that if the passage is innocent, it must not be prejudicial to the safety and security concerns of the coastal state. While it undertakes right or exercises right of innocent passage, it must also comply with the rules and regulations that have been conveyed to the ships navigating through those routes by the coastal state. It also has the right to anchor or if it is in distress, or if any force majeure comes into being, it can halt for a certain period of time. So, your innocence can be or will be identified by the coastal state to a certain extent. If the coastal state feels that any action of the ship navigating is prejudicial to the safety and security of the coastal state, it can suspend the innocent passage of that particular ship. So, the idea of mare clausum as well as the idea of mare liberum has been compromised by bringing in freedom of navigation and attaching it with the idea of innocent passage, that you can pass through, but it must be innocent in nature. In general, the passage must be continuous and expeditious. Article 20 says all submarines and underwater vehicles must navigate on the surface. Well friends, you must be knowing that submarines generally travel underwater. You cannot identify whether a submarine is passing through or not, but once it enters territorial waters, it must come above the surface and must show flag. Without coming above the surface and showing flag, it will be considered that the submarine's passage is not innocent. Meaning of innocent passage: passage is innocent so long as it is not prejudicial to the peace, good order or security of the coastal state. Such passage shall take place in conformity with this convention and with other rules of international law. Passage of a foreign ship shall be considered to be prejudicial to the peace, good order or security of the coastal state if in the territorial sea it engages in any of the following activities: any threat or use of force against the sovereignty, territorial integrity or political independence of the coastal state, or in any other manner in violation of the principles of international law embodied in the Charter of the United Nations. Clause B, any exercise or practice with weapons of any kind, any act aimed at collecting information to the prejudice of the defense or security of the coastal state, any act of propaganda aimed at affecting the defense or security of the coastal state, the launching, landing or taking on board of any aircraft, the launching, landing or taking on board of any military device, the loading or unloading of any commodity, currency or person contrary to the customs, fiscal, immigration or sanitary laws and regulations of the coastal state, any act of willful and serious pollution contrary to this convention, any fishing activities, the carrying out of research or survey activities, any act aimed at interfering with any systems of communication or any other facilities or installations of the coastal state, any other activity not having a direct bearing on passage. So, if any of these activities are undertaken by the ship passing through territorial water of the coastal state, then it can be considered to be a passage not innocent, and in that scenario passage can be suspended. Appropriate action may be taken by the coastal state. Then you have rights of the coastal state in territorial sea. Article 21 says the coastal state may adopt laws and regulations in conformity with the provisions of this convention and other rules of international law relating to innocent passage through the territorial sea in respect of all or any of the following: the safety of navigation and the regulation of maritime traffic. That is, if the coastal state is having certain rights in territorial sea, it is also having the certain duties which comes up as a right or contrary to which it gives certain rights to the ship. If ship is having freedom of navigation, it is the duty of the coastal state to provide safe passage. If coastal state is having the right against the ship, then ship is also having at the same time duty that it does not act prejudicial to the interest of the coastal state. Okay. So, there are corresponding rights and duties against each other. So, it is the duty of the coastal state to provide safe navigation and regulate maritime traffic. It also has the right to protect the protection of navigational aids and facilities and other facilities or installations. So, it has right to install, it has duty to facilitate ships that are passing through its coastal area. The protection of cables and pipelines, it has all those rights as well, and at the same time duties, if the pipeline belongs to some other state, it has a duty to protect those pipelines. The conservation of the living resources of the sea, the prevention of infringement of the fisheries laws and regulations of the coastal state, the preservation of the environment of the coastal state and the prevention, reduction and control of pollution thereof, marine scientific research and hydrographic surveys, prevention of infringement of customs, fiscal, immigration or sanitary laws and regulations of the coastal state. Now, if you look at marine scientific research and hydrographic surveys, it extends up to 200 nautical miles, that is exclusive economic zone, and if you look at the prevention of infringement of customs, fiscal, immigration and sanitary laws, it can extend up to contiguous zone and if you look at sanitary aspect, it can extend up to exclusive economic zone as well. Article 25 talks about rights of protection of coastal state. The coastal state may take the necessary steps in its territorial sea to prevent passage which is not innocent. In the case of ships proceeding to internal waters or a call at a port facility outside internal waters. So, the water between the baseline and falling between the coastline will be known as internal water. So, wherever a ship wants to enter into internal water or wants to come towards the port, the coastal state also has the right to take the necessary steps to prevent any breach of the conditions to which admission of those ships to internal waters or such a call is subject. The coastal state may, without discrimination in form or in fact among foreign ships, suspend temporarily in specified areas of its territorial sea the innocent passage of foreign ships if such suspension is essential for the protection of its security, including weapons exercises. What are the duties of coastal state in territorial sea? Article 24 says, the coastal state shall not hamper the innocent passage of foreign ships, which comes up as a right as far as the ships are concerned, through the territorial sea except in accordance with this convention. In particular, in the application of this convention or of any laws or regulations adopted in conformity with this convention, the coastal state shall not impose requirements on foreign ships which have the practical effect of denying or impairing the right of innocent passage, discriminate in form or in fact against the ships of any state or against ships carrying cargoes to, from or on behalf of any state. The coastal state shall give appropriate publicity to any danger to navigation of which it has knowledge within its territorial sea. An example could be taken from Corfu Channel case, where English ships were passing through Corfu Channel. Albania was held responsible because it did not pay due diligence and its due duty was not complied as far as presence of those mines were concerned. It was a negligent act as far as Albania is concerned, as British ships were passing through Albanian or Corfu channels, or you can say Albanian waters. Albania was held responsible. It was Albania's duty to take care of its territorial waters as far as any danger to ships passing through Corfu channel is concerned. Now, apart from territorial sea, what is the legal status as far as contiguous zone is concerned? It is a zone to territorial sea. It is described as the contiguous zone. The coastal state may exercise control necessary to prevent infringement of its customs, fiscal, immigration or sanitary laws and regulations within territory or territorial sea. We must note that till territorial sea, territorial or legislative jurisdiction gets applicable. That is, all the legislative laws gets applicable as far as 12 nautical miles, up to 12 nautical miles or territorial sea is concerned. But beyond 12 nautical miles, that is from the point where territorial sea ends and up to next 12 nautical miles, that is the contiguous zone, extraterritorial jurisdiction gets applicable and it will be concerned with customs, fiscal, immigration or sanitary laws. Next, it may punish infringement of the above laws and regulations committed within its territory or territorial sea. So, territorial laws does not get applicable or legislative laws does not get applicable in contiguous zone as compared to your territorial sea. Only certain laws get applicable which are with respect to customs, fiscal, immigration or sanitary. Then you have a exclusive economic zone, which we know that 200 nautical miles from the baseline. Now, reasons I have more or less already told you, which are political and historical. No biological, geographic or ecological significance comes into being. Chile had a claim of 200 miles due to its offshore whaling operations. Islands can have their own exclusive economic zone. Not only that, but they can also have territorial sea and contiguous zone as well. So, as far as rights and jurisdiction and duties of coastal state are concerned with respect to EEZ, Article 56 says that in EEZ, the coastal state has sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or non-living, of the waters suprajacent to the seabed and of the seabed and its subsoil, and with regard to other activities for the economic exploitation and exploration of the zone, such as the production of energy from the water, currents and winds. Jurisdiction as provided for in the relevant provisions of this convention with regard to establishment and use of artificial island, the coastal state can establish certain installations, can develop artificial island in that particular region, certain other structures, marine scientific research can be undertaken by the coastal state. The protection and preservation of marine environment is the right of the coastal state, other rights and duties provided in this convention. In exercising its right and performing its duties under this convention in the EEZ, the coastal state shall have due regard to the rights and duties of other states and shall act in a manner compatible with provisions of these conventions. So, at the same time in EEZ, other states also have certain rights, that is they can fly planes over the EEZ, that is they also have right to navigation with respect to sea lanes, pollution control as far as coastal state is concerned, overflight which should be innocent flying, and all of this is governed by International Civil Aviation Organization as far as usage of air traffic is concerned. It can also lay down submarines and pipelines, but should not hamper the economic interest of the coastal state, but generally the other states have the right to lay down pipelines and submarines. The next important aspect with respect to coastal states right is doctrine of is lying under doctrine of hot pursuit. So, if a particular ship, let us say belonging to any other state, enters into the territorial waters of a particular state, let us say Somalian ship enters into, or any other ship, let us say pirate ship enters into coastal waters of the India in territorial sea and conducts piracy and then tries to run away or flee away. The Indian coast guards or Indian ship can pursue that particular pirate ship or ship belonging to any other state for that matter if it has committed a wrongful act, and it can pursue up to the pursue that particular ship which has committed the wrongful act in the contiguous zone or in EEZ of its own state, or EEZ of other state or contiguous zone of other state, or in high seas. The only restriction that we see under UNCLOS that it cannot pursue or it cannot undertake hot pursuit in the territorial waters of any other state. So, article 111 of UNCLOS 1982 provides and says that if a foreign vessel engages in any criminal activity within the state's territorial waters, the pursuit of that vessel will begin immediately and may continue on the high seas and will be legitimate if an arrest is made. It enables a law enforcement agent to pursue a suspect who may be evading capture by fleeing to international waters. Hot pursuit, as the word suggests, is the immediate or recent pursuit of a criminal suspect by those posing as law enforcement officers. There are certain important aspects that must be undertaken as far as hot pursuit is concerned, that it must be immediate, it must have it must be continuous in nature, it must have warned, investigation must be continuous. Certain important aspects are to be taken into account as far as hot pursuit is concerned. An important case with respect to hot pursuit would be I Am Alone case, wherein a Canadian registered ship called I Am Alone was smuggling in US territorial sea in 1929, and in this case the ship that was pursuing I Am Alone, which was known as Dexter, after 200 nautical mile, Dexter began a close pursuit and opened fire on I Am Alone ship. Now, this Dexter ship did not pursue I Am Alone ship in a continuous manner. It came after, or you can say later on, once the original ship that was pursuing left pursuing I Am Alone ship. So, the chasing or pursuing was not, or the hot pursuit was not continuous in nature as far as Dexter ship was concerned. So, it must be continuous and it must be immediate. With these restrictions, we see hot pursuit can be undertaken by the state. So, with this we come to an end as far as this class is concerned. See you in the part 2 of Law of the Sea lecture. Thank you so much. Namaskar.